Hello. Hi, everybody. Hopefully I'm not too quiet. I'm not too loud. You know what I mean. You guys can let me know. Sorry, part of this is a little bit unseeable. It's, because if I do that, then that happens. So, the brief, the non-sequitur court proceedings, part 1. I'm excited. So, welcome to the Answers and Reason blog or website. Definitely recommend it. They're fantastic. They've always been fantastic to me. They're very reasonable people, interestingly enough, and they've always been a lot of fun. This is their first guest article, so I guess this is a little bit special in that this is the first time they've had a guest, so there's a debut there, and also this is written by our very own Intrigued Feline, and if anybody hasn't said it yet, she has been a treasure to this community. She's been a wonderful addition, and she has just been fantastic to everybody. She is always, like, very charitable, very reasonable when she speaks. She doesn't break down like I do into name-calling, because I definitely do that. I don't start it, usually, but, you know, it takes all different kinds. Oh, I'm a little bit quiet. I can adjust that. Is that better? Is this better? Hello? There we go. Okay. So, yes. We are getting so close, hopefully, to the end of this. The next date on the calendar is November 5th, and of course, remember the 5th of November, the gunfire treason and plot. I know of no reason why the gunpowder treason should ever be forgot. That is 1 week from now. Some of you may have noticed that I posted that on Twitter. The song, 1 week. So, eel 'em out. So, this is a sort of a brief, and it is part 1. And it's part 1 because, if I'm not mistaken from reading this, she is not going into the deposition yet. She's just doing a little bit of an introduction and breakdown before doing the deposition, which, you know, makes sense to me. So, here we go. Oh, that's no good. That shouldn't affect that. Good. All right. Whew. Here we go. Introduction. The community requested me to make an analysis of the deposition of Kyle R. Curtis in regards to the civil lawsuit between Mr. Curtis and Stephen McCrae. Previously, I had done a similar breakdown on court documents filed by Mr. Curtis on Twitter. I've seen those. They're actually fantastic. However, as the deposition is rather lengthy, a breakdown of this on Twitter would make it probably or possibly very difficult to follow with a maximum of 208 characters per tweet. Reasonable. Upon request, I was generously permitted to make this guest post so it would be easier to structure and follow the breakdown. Thank you, Answers and Reason. Before I get to the analysis of the deposition, I would like to give a brief summary of the court proceedings of McCrae versus Curtis, 19 CVS 8163. So if anybody needs to find it. And my apologies if it is getting a bit technical. Judicial matters are often rather complex. Throughout the post, I will refer to direct electronic court filings, ECF, which can be accessed within the United States through the following website and searching for either Curtis or McCrae. I actually use the judge, but that's just me. Because it's a drop-down, I don't have to type anything in. The two people involved in the court case were co-owners of a YouTube channel called The NonSequitur Show, or NSS for short. The purpose of the show was that anything could be discussed and opinions were sacred. The channel was created in the winter of 2017 through 2018, with the first episode airing on YouTube on February 18th, 2018. Eventually, the show attracted well-known people such as Aaron Ra, Matt Dillahunty, and Landon Kurt Knoll. It appeared to run well and saw a steady increase in popularity. At its peak, the revenue was around several $1,000s a month. This was to be split between Mr. McCrae and I read that backwards. Mr. Curtis and Mr. McCrae. I don't know why I do that. And this is... I think I read too far ahead. And this is where we start to get to, this is where we get to the start of the breakup. Wow. On June 11th, 2019, Mr. McCrae confronted Mr. Curtis with several issues. He had been requesting the financial records on several occasions over several months, and yet had not received it or received any significant income from the show's revenue streams. By significant income, she means zero. Additionally, in the several months preceding the confrontation, he had noticed he was being scheduled less and less for the show, despite his efforts to bring in guests and topics for the show. In this confrontation, Red's Rhetoric, a regular on the show, acted as a mediator between Mr. Curtis and Mr. McCrae. The whole confrontation was recorded and can be watched here. Da-na-na. During this confrontation, Mr. Curtis was given multiple opportunities to have the situation resolved amicably. Unfortunately, he declined and told Mr. McCrae to sue him, and so Mr. McCrae did. Sue me, okay. I forget how, like, what's the word? Obstructive? I don't know. Arrogant, maybe Kyle was big? Sue me, Steve. Alright. If I have to. Memories, colors of the way we were. Court proceedings. On August 23, 2019, Mr. McCrae filed with the North Carolina Business Court, and the case was assigned to Judge Gale. On the same day, service papers were sent to the last known address at the time. These were signed by Mr. Curtis's mother on August 30th at the same address. According to Rule 4 of the North Carolina Civil Rules and Proceedings, this raises the presumption of service. To elaborate, Rule 4 governs the regulations regarding the service of process. These rules must be abided for service to be deemed proper. Mr. McCrae filed according to Rule 4(1)(c). Quote, by mailing a copy of the summons and of the complaint, registered or certified mail, return receipt requested, addressed to the party to be served, and delivering to the addressee, end quote. Obstinate? Yeah, maybe. It's a good word. Upon receiving the return receipt and filing that with the court, ECF 7, the presumption of service is raised according to Rule 4(j)(2)(2). Ellipses, with delivery receipt, the serving party shall file an affidavit with the court showing proof of such service in accordance with the requirement. Ellipses, delivery receipt signed by the person who received the mail or delivery. If not, the addressee raises a presumption that the person who received the mail or delivery and signed the receipt was an agent of the addressee. Ellipses, end quote. Therefore, the burden is now on to Mr. Curtis to rebut the presumption of service or to respond to the lawsuit. He did neither, despite clearly being aware of the proceedings. In several online discussions, which were recorded, Mr. Curtis had talked about the case and allegedly received the original papers that he was served. The original papers, the original papers that I was served, papers that I was served, papers that I was served. Gold. As Mr. Curtis did not appear before the court with any filings whatsoever, the court had notified Mr. Curtis with the intent to enter a default judgment of the proceedings in the case. Mr. Curtis did not respond. ECF 16. Absent Mr. Curtis's response, the court ordered the entry of partial judgment by default, ECF 17. With this order, Mr. Curtis is required to hand over administrative control. Mr. Curtis, this order Mr. Curtis is required to hand over administrative control and primary ownership rights of the NonSequitur Show podcast, YouTube channel, and other accounts associated with NSS. Mr. Curtis is required to hand over all financial documents associated with the NonSequitur Show financial affairs and financial condition. Additionally, as a result of the default judgment, Mr. Curtis has been found liable for breach of contract, fraud, conversion, breach of fiduciary duty, and unfair and deceptive trade practices. Consequently, Mr. McRae was entitled to 50% of the NonSequitur Show proceedings prior to his removal of the NonSequitur Show with additional treble damages. This is the order from last year. This is a brief overview. Initially, Mr. Curtis attempted to comply by filing a document that is purported to be the financials as ordered by the court ECF 18. So, just a note for any of you who have seen the deposition of Kyle Curtis over on Red's Rhetoric's channel, or have read it yourselves, you may recall Kyle saying in that deposition that he never received any paperwork from the court. Never received any paperwork from the court. Yet, he responded to it purporting to comply with what the court was saying. How could he possibly have responded properly to something he never received? Was he just looking it up? I don't know. Anyway, initially Mr. Curtis, you guys let me know what you think. Initially, Mr. Curtis attempted to comply by filing a document that is purported to be the financials as ordered by the court ECF 18. It is my opinion that this document is woefully incomplete and is not to the standard one would expect a business to record their financials. This document has been dismissed by Mr. McRae as the purported financial documents are unsupported summaries. ECF 22. Several days after Mr. Curtis's attempted compliance to the default judgment, Mr. Curtis filed a motion to set aside ECF 19/20. In this motion, Mr. Curtis alleges that service was not proper due to his address being different than where the summons was. I think that's supposed to was where the summons were actually sent to. Where also works. Both those words would work. For months, this would be his primary argument in an effort to get the default judgment overturned. During this time, he refused to comply with the default judgment. As long as the default judgment stands, Mr. Curtis would be in contempt of court ECF 23-27. In his motion to set aside ECF 19/20, Mr. Curtis filed several documents that purportedly show his address being somewhere else. These documents pertain to alleged Discover bank statements from August and November 2019. Additionally, Mr. Curtis filed a purported rental agreement with a certain Mr. Potts, his boyfriend at the time. Furthermore, a declaration purported to be from Mr. Potts where it was stated that Mr. Curtis allegedly lived at the other address. The documents I have mentioned here would later become quite important to this case. So Reed just said something and I just want to clarify. Best part of the depo, Steve's lawyer, would you ask your mom to throw your would you ask your mother to throw your mail away? Kyle, no, why would I do that? Scotty Lee, that's a great question. Kyle, I have to use the bathroom. Lamau. Actually, Kyle didn't say no. Steve's lawyer said, have you ever asked her to throw any of that mail away? He said, why would I do that? Steve's lawyer then said, that's what I'm asking. Or good question. I sniff my finger. Listen, I have this lovely, lovely, smelly... It's just to calm me down, okay? Thus far, Mr. Curtis was proceeding pro se on his own. This changed on July 9th when the counsel for Mr. Curtis appeared before the court. Mr. Curtis's lawyer has refiled to amend the motion to set aside ECF 30 to 31. The main argument, however, remained the same. The service was improper because it was not sent to his alleged residence. With those filings, Mr. Curtis also filed the aforementioned Discover bank statements and the signed documents. Henceforth, there was a little back and forth where both parties filed affidavits laying out their arguments. It wasn't until August 24th where Mr. Curtis had changed his argument from service at the wrong address to never having received papers at all, ECF 33.1. Shortly after that filing, the judge ordered a hearing to appear, ECF 34. Initially, this was to happen on September 11th. However, Further recent filings by Mr. McCrae gave significant indications that several documentations filed by Mr. Curtis had been altered prior to filing with the court, ECF 38 to 40. This came to light as Mr. Potts had reached out to Mr. McCrae on September 6th. During their chat, it became clear that Mr. Potts, which you can hear, the hearing to appear is on this channel, so you can find that. During their chat, it became clear that Mr. Potts had never signed any of the documents that Mr. Curtis had filed with the court. This means that the rental agreement, as well as the declaration, both were forgeries. As a result of that, the documents were also checked, and it came to light that the Discover statements were also altered, among other documents. This resulted in the hearing to be postponed by several days, giving Mr. Curtis time to respond to the allegations made and to give the court time to verify some of the assertions made by Mr. McCrae. Here, Mr. Curtis did file a response, ECF 44, in which new evidence was presented. During the hearing, it became clear that the initial argument was not sufficient to rebut the presumption to set aside. The judge had pointed out that even if Mr. Curtis had lived at the other address, if he was given the papers by his mother in time, if he was given the papers by his mother in time, then service would have been proper. Mr. Curtis's lawyer agreed. Though, due to the August 24th filing by Mr. Curtis, the judge was in a quandary as not having obtained the papers in time would suffice to rebut the presumption. However, already early on, Mr. McCrae had filed several recordings in which Mr. Curtis was talking about the case and had made several references to the original papers he was served. That is also on this channel, because of course it is. This created diametrically opposing statements between Mr. Curtis and Mr. McCrae. Oh hey, this is it. That's the video. Yeah. It was not only diametrically opposing statements. Mr. Potts had given a declaration stating that the documents with his signature were false and that it was not his signature. This also created a dichotomy. Therefore, the judge had requested the deposition of both Mr. Potts and Mr. Curtis in regards to the service. It essentially became a determination of credibility, as someone had to be lying to the court. A transcript of the hearing can be heard here. Yay! And so, now we get to the depositions. The most interesting of the two depositions is the one with Mr. Curtis, 'cause of course it is! This will be highlighted on a separate page, in case anyone wants to catch up with most of what has been said publicly about the court case. Chesh, that's me, has made a publicly accessible spreadsheet where most of the information can be found. Yay! Additionally, as I referred to earlier, all the publicly available court records can be accessed at the court's website, and search for either Curtis or McCrae, and you should find it. The case identification number is 19 CVS 8163. If there are any questions or comments, you can either comment below or reach me on my Twitter at IntriguedFeline. Yay! This is really good. It definitely, it brings to light how much, but also how little has happened in such a long period of time. Like, when you break it all down to its basics, there's not a whole, like, there's a lot, and it takes a lot of time, but it's been so long, and it's hard to just kind of wrap your mind around what has actually been filed to the court and what has actually been just, like, talked about over and over and over again. So it's really bizarre that way. In that, I think I brought this up on a stream one of the times, is that we've seen, anybody who's been watching and following us, or we've talked about, or people who've been following, some other people who've been covering the case, have seen kind of where this pivot from one argument to the other came from, and sort of why, and that makes sense. But to the judge, it just went from making this argument to making this argument, and doesn't have all that in between information. So it ends up making it really interesting. I'm looking forward to the next installment of the depositions. This is really good, and appreciated to having a guest article for Feline, and also from Answers and Reason, who are great in my opinion. They're hilarious. I had them on here. We were discussing Arn Ra's blog about atheism, and so there was a lot to that ended up being 3 parts. So look forward to part 2. That will definitely be a thing that I will be reading. This was fantastic. Thank you everybody for coming. If you guys have any questions, and so this link down here, this will be linked in the video description, but this link here to my to this spreadsheet will also be linked. But also, if you look at my created playlists, I made 2 new playlists. One is 12 videos, and it's the initial stuff that went on, and then the other one is any updates that have gone on. So I'll add this video and then also the next video, but that playlist also exists. So if you guys don't want to use the spreadsheet, or the spreadsheet seems a little bit overwhelming, because it kind of can seem that way, and I totally get why, you can actually just go and find the playlist, and it'll be fun to watch which ones get removed later, because I'm sure some of those videos will end up privated or deleted. Anyway, thank you everybody for coming. I hope you all had a good time. I hope you all enjoyed. I thought this article was really good. Go check it out and read it for yourselves. Links will be in the description down below. And have a good day, everyone. Bye.
Ba-da-da-da-da.